What happens in court? You must show up at the date and time listed on your temporary restraining order so that the matter can be heard by a judge. You are the plaintiff and the abuser is the defendant. If you are unrepresented or pro se, go to court and have a seat in the waiting area outside the courtroom where your matter will be heard. Some courts have a separate waiting area where domestic violence victims can sit while they wait for their case to be called. Other courts do not have a separate room, so the plaintiff and defendant should take seats as far away from each other as is practical. If you see the defendant, sit in an area away from him. If you feel threatened, notify the nearest sheriff's officer. A different sheriff's officer is assigned to each courtroom. When the sheriff's officer for your courtroom comes out to ask who is present for that judge, you need to check in by letting the sheriff's officer know that you are present. You want to let the sheriff's officer know if you plan on proceeding with obtaining the final restraining order, how many witnesses you have, and if you need an interpreter. If English is not your native language, you should request an interpreter. If you need an interpreter other than Spanish, it is a good idea to call the court to request one beforehand. Testifying in a courtroom is a stressful experience for most people, and even those who find they can speak English in other settings might find it difficult to find the right words under the pressure of a court hearing. After checking in, you can retake your seat. You can spend the time reviewing your case. If there's nothing to review, spend the time trying to relax. On the day of the final hearing, a couple of things may happen. Either party may show up and request an adjournment, which is simply extra time to better prepare, to obtain an attorney, request an interpreter, etc. If this is the first court date for your matter, that request will likely be granted. If you and the defendant both appear, the matter may proceed. You should always assume that the case will proceed on the final hearing date, and you should therefore arrive on time and plan to be in court all day. Or one party may fail to show up for the hearing. If that happens, the matter may be adjourned for this reason as well. However, as the plaintiff, you should be aware if you do not appear for the final hearing, your temporary restraining order may be dismissed. If you, the plaintiff, appear and the defendant does not appear, the judge may either adjourn the matter or allow you to proceed with the presentation of your case. Once you are called in for your case by the sheriff's officer, you will be seated at a table on one side of the courtroom, and the defendant will be seated at another table. If either of you have an attorney present, the attorneys will be seated with you at your tables. If an interpreter is needed, the interpreter will sit either in between the two tables or with the party for whom the interpreter is needed. When the case begins, if present, the attorneys will introduce themselves and their clients to the court. You and the defendant will then be asked to swear or affirm that everything you say is the truth. The hearing will then begin. You, the plaintiff, as the party bringing the lawsuit, will present your case first. If you have an attorney, your attorney will ask you questions and you will answer them. If you do not have an attorney, the judge will ask you the questions. This is called direct examination. You will be given the opportunity to testify, tell your side of the story, and then present any relevant evidence and other witnesses to the domestic violence incident or incidents. The defendant or his attorney may object to the presentation of any testimony or evidence they see as inappropriate. The judge will then either sustain the objection, preventing the speaker from testifying or presenting evidence about a certain aspect of the case, or overrule the objection, allowing the speaker to continue in the presentation of testimony or evidence. Remember that if you hear either attorney object to a question or answer, you should stop talking and listen to what the judge decides. The judge will tell you whether or not you may continue to testify. During a final restraining order hearing, you have to prove certain elements by what is called a preponderance of the evidence. Preponderance of the evidence simply means your version of events is more likely than not to have occurred than the defendant's version. There are 3 things that you need to prove by this standard. First, you need to prove that you are in a relationship recognized by the Prevention of Domestic Violence Act. Your relationship with the defendant must fit a certain criteria. Were you and the defendant married? Are you married now? Did or have you lived together? Do you share a child? Were or are you in a dating relationship? Secondly, you must prove that a current act of domestic violence was committed against you. This act must be one of the 14 crimes that you can see on the first page of your temporary restraining order. This is also the current incident that is captioned on the first page of your temporary restraining order above those 14 listed crimes. The judge will decide if a current act of domestic violence has been committed against you by considering a history of domestic violence that was committed against you, referenced immediately below those 14 crimes on page 1 of your temporary restraining order. The final element you need to prove is that you are in need of the protections of a final restraining order. That is, without a final restraining order, there would be immediate danger to your person or property. This is required because the law says that a single act of domestic violence may not be enough to result in a final restraining order. The way you prove these elements to the judge is by testifying, telling your story under oath in court. Your story should be the same every time, and answer all questions honestly. Remember that if the judge finds that you are not telling the truth about even a minor fact, he or she may then not believe the rest of your testimony. You must also answer questions from the defendant's attorney or the judge simply, honestly, and directly. Try not to argue with anyone who is asking you questions. When testifying to the court, there are a few important rules to keep in mind. You are not allowed to offer testimony that is hearsay. Hearsay is a statement that was made by someone else outside of the court that you are presenting as the truth. For example, my mother said she saw the defendant slash my tires. That is hearsay evidence and cannot be considered by the judge. If you feel the evidence is important, you should ask your mother to come and testify directly to the judge. Evidence might include photographs of your injuries. Even if the police have taken photographs of your injuries, it is a good idea for you to take your own pictures and bring them with you to court. After you testify about receiving a particular injury, you should make the judge aware that you have pictures of your injuries. The sheriff's officer will take those pictures from you to show them to the judge. It is important to tell the judge that the pictures you are providing are true and accurate representations of what you testified. If you sought medical attention because of your incident of domestic violence, you should request your medical records. It's important when you request your medical records that you ask that they be certified. This means that your records will have a cover sheet on the top that tells the court that the records are true and accurate copies of your medical records. This cover sheet is necessary for the court to consider the contents of your medical records. After you testify about seeking medical treatment, you should ask the court to review these medical records. There are many different types of evidence, including text messages, voicemails, or phone records. The goal of evidence is to support your testimony and help you to meet your burden, the preponderance of the evidence. With any evidence you submit, it is important for you to authenticate it. This means you must testify that the evidence you are providing is an accurate representation of the facts. You want to tell the court what this evidence is, how you obtained it, and how it helps your case. You have the opportunity to present other kinds of evidence. This might include witnesses to acts of domestic violence committed against you. Any witness who comes to court with you must have personal knowledge of an act of domestic violence committed against you. If you are going to have a witness, they must be in court with you that day. The court cannot consider a letter from your witness, even if notarized. You may want the police officer involved in your case to testify at your final hearing. In order to do that, you need to provide notice in the form of a subpoena. The court rules say this notice should be provided at least 5 days before your hearing. You would want a police officer to testify when that officer has personal knowledge of what happened in your situation. This may occur if they have seen your injuries, if the defendant admitted to an act of domestic violence, if they saw damaged property, or if they can testify to your demeanor. Once you finish testifying, the defendant or his attorney will have the opportunity to cross-examine or question you. Cross-examination is an opportunity to flush out any inconsistency in the other party's testimony. Similarly, any witnesses who testify will be cross-examined as well. After being cross-examined, the plaintiff will usually have the opportunity to explain any inconsistencies that were raised during cross-examination. The vehicle for this is redirect examination. Here, the plaintiff's attorney will ask the plaintiff additional questions to clear up any seeming inconsistencies brought out by the defendant or his attorney. Or if you are not represented, you will have one final opportunity to talk about the domestic violence. Once the plaintiff has finished, the defendant will be given the same opportunity to testify and present witnesses and evidence. Now you will have the opportunity to cross-examine the defendant and object to any testimony or evidence deemed inappropriate. Throughout the proceedings, it is important to show respect not only to the court and your own attorney, but also to the defendant and his attorney. It is therefore not appropriate to laugh or sigh loudly, throw your hands into the air incredulously, or otherwise blatantly show your frustration while the defendant is presenting his case. This not only detracts from the overall proceeding, but may also irritate the judge and the attorneys. When you and the defendant finish presenting your cases to the court, the judge will then give his or her opinion. While the judge is giving their opinion, you are not allowed to speak or present any additional evidence. During their opinion, the judge will inform you whether your temporary restraining order will be dismissed or become final, and provide reasons for his or her decision. If you would like advice or possible representation at the final restraining order hearing, please contact the Domestic Violence Representation Project at Legal Services of New Jersey by calling 1-888-LSNJ-LAW.